Hi, this is Matt Kameyer with Five Star Real Estate. Just wanted to give you a run through since we can't meet in person of what our initial disclosures with the state and the documents to hire us involved with our buyer clients. So here, you'll get the email asking you to sign the agreement and disclosures, and you just click on that, and it'll pop open an internet browser to this page. You will just go ahead and either approve your signature. I usually just do the one that's given to you, or you can select different fonts, draw your signature, whatever you would like. You can see that they have the um, agreement for the electronic user and e-signatures all here. I'm going to go ahead and accept that. And it brings you to our documents, which we'll go through. So to start, this form is called the duties owed. What this does is explain all the duties that I, as a real estate agent and broker, um, have to the general public and to you as a client. Not only do I have to deal with all parties in a manner which is not deceitful, fraudulent, or dishonest, but I have to exercise reasonable skill and care, and I have to disclose any pertinent facts about the property that could affect its value or use. I also have to keep your information confidential for at least a year, and a few other terms that are listed down here. This form also notates, if you were working with somebody that wasn't the broker, it would list the agent's name and then the broker, somebody different. But obviously I'm the broker and the agent, so I'm listed in both places here with my company, Five Star Real Estate and Property Management. As you get down to the bottom, you'll see a couple spots. So this one happens to be set up for my signature, so I'm going to sign it as we go through, but wanted to use this to show you what to expect. So on the duties owed form, you have the option for may or may not in the future act for two or more parties. So in the state of Nevada, we can represent more than one party. So for example, if I had a great listing and it fit all of your needs, I would be able to represent both of you in that transaction. And in advance of that, you have to agree to may or may not act in that manner. If you do say may, and it does come up to that situation, which is actually quite rare, um, I would have to have other forms that disclose in greater detail the situation um, so that all parties understand the process. So with that, you'll go through, you'll click the form, and just to give you an idea of what to expect, I'm just going to scroll way down to the bottom where there are some signature lines. So you'll see these little boxes like this, red with the yellow in the middle. You'll just look for those, or you can just do it the easy way, push start, and it'll take you right to where you need to go. So you'll do that, you'll initial, sign, and the date and everything will populate just for you. We have a second page that lists a few of our agents, licensed people. They have the same duties that I do, so I like to disclose that those people are also associated and owe you the same duties in the transactions. So you'll sign that page as well. The next document, and don't be afraid, this is really just one big document. This one is a little over 30 pages. It's called the Residential Disclosure Guide, and it discusses just about every disclosure there is in Nevada. So if there's anything you're curious about at all, you can go through. Luckily, there's a nice table of contents. You can see there's over 30 pages of disclosures. One of the big ones that we can talk about is the seller's real property disclosure form, but we can get into a few of those. We're going to go through the brokerage agreement hiring us, and then also I wanted to go through a uh, real live purchase agreement. So if you are signing these on the run, we're making lots of offers or something, you know exactly what you're signing in advance of that. And if you have any questions, then we can talk about those before you even make an offer. So anyway, this residential disclosure guide, we're going to skim all the way down because all we need to do is really sign, and you'll get an email with a copy of all of these documents that you've signed immediately once we've both signed. So as we scroll down, there's just a signature page here. The little pop-up will come here. It'll auto-populate the date for you, and it'll let you move on to the next document, which is our before you purchase a property in a common interest community, did you know? Common interest community, also known as a CIC, is the same thing as your HOA. If you're buying a property without an HOA, then this form will not apply. But Most of the communities in Southern Nevada actually do have common interest communities. So, this form is telling you that you have 5 days to cancel the purchase agreement. So when we open escrow, the seller will have some duties, the buyer will have some duties. One of the duties the seller has is to provide you with the HOA resale package. So what this does is it explains all the rules, regulations, CCNRs, budgets, any litigation, anything like that. And it usually does take a week or two to get back from the HOA, so you don't get it immediately. But you do have the 5 days to cancel from the point that we do get that. If you're When you purchase within a CIC, you are agreeing to restrictions on how you can use your property. So a couple examples that I've run into are, let's say you have 8 cars and the HOA doesn't allow street parking. That's going to be a problem for you. Or let's say you have 4 dogs and the HOA only allows 2. That could be a problem for you. Now, that doesn't mean that, throw your hands in the air and, it's a no-go. I have had some HOAs give us written waivers to allow more dogs than 2. So, there could be some options there, and I'm willing to fight for you if it's something you really want to do. The next item, you will have homeowners dues for as long as you own the property, and they can foreclose and take your property if you don't pay them. So you also have the right to become a member of the HOA, the board, one of the great thankless jobs out there, but if you want to make your community better, that's one of the best ways to do it. Also, just like the sellers, when they were providing you with the resale package, you also have to provide the resale package to potential buyers when you go to sell the property down in the future. You do have rights that are guaranteed to you in this state, and if you have questions or feel you've been wronged, you do have 2 offices put together by the state of Nevada. Um, we have one in Southern Nevada and one in Northern Nevada, so you do have options to call or visit either of those. Again, you'll sign here, it'll automatically populate date and time. So the buyer brokerage agreement is the form which hires us to be your exclusive broker. So, in this form, we have Liliana's name right here. We have it dated March 1st, and we usually run it 4 to 6 months. So we went ahead and went to August 1st. This is to purchase residential real estate, and it lists a few things here. So it notes that the buyer is agreeing to work with the broker exclusively and more or less not run around town and have 10 of these agreements with all kinds of different brokers. Um, as a real estate agent, we work on a contingency basis. So until we close on the right property for you, we don't get paid. We're not taking fees in advance, nothing like that. So we only collect our payment once we've successfully closed on a home for you. So due to that and the work involved, we do request that we be your only agent to be working with. Um, there's a number of items here. We all have to act in good faith. If you are looking at new homes, the new home builders will want you to have us accompany you or somebody on my team with you the first time you visit the property. After that, you want to show the whole family 20 times, that's fine, no problem. But take us with you the first time you go to look at the new homes and sales lots. Um, so, a lot of this is really just we are your agent and we hold a Nevada license. We agree to work diligently and negotiate on terms that you request. So broker's compensation, that's one that usually gets the most questions. So you'll see that I actually have this at a slightly lower amount than what a lot of people do at the 2.5% commission. So that's not something that you typically pay for. As you'll see as you start to look at some of the listings, you'll see that the amount that the seller is paying will more than cover any commission that's listed here. Now, what this does for us, though, is give us an advantage. So there are some companies that do not pay commissions, like auction.com or Zome or something like that, where there might be some opportunity to find you the right property, just not in the traditional methods. So what this does is it gives us the opportunity to make sure that we're working hard for you, and frankly, that will get paid at the end of the day. So what we do is let you know, say, hey, we found this great home on auction.com, for example. However, they're paying a $10 commission. So we need to structure our offer so that, not only are you getting the home, but we're also being compensated properly as well. Um, Realistically, the only fee that you should be paying and that you would see on the closing statement is this $350 dot control fee. We do have to store all our documents for 7 years, and we share that cost with you. Otherwise, this agreement is good during the dates, commencing and expiring. If we are the procuring cause of um, the home for you, we find the right place, all of that, we do expect to be paid. If you go into um, contract on that home, within 180 days of termination of this agreement, uh, we are due a commission. Disclosures, we already went over the duties owed. If we do work for both a buyer and a seller, we would have to get the consent to act. That's one of the forms I was referencing earlier. This also notes that we do work with more than one buyer at a time. Um, we do need to keep your information private um, unless we have your authorization in writing. All information that is out on the internet is public, so if a seller has pictures out there, they will probably remain out there in perpetuity. We also have to work in equal housing. We do not discriminate and will not tolerate it, and we have fired clients that have asked us to discriminate multiple times. Um, Mediation. So our board of realtors actually offers a great mediation program. I think it's like $100 per party, something like that. But both parties need to agree in advance to that. And you'll see the same section in the purchase agreement. So um, we actually do a great job of governing ourselves. I've sat on the grievance committee, and everybody down there really cares about everyone doing the right thing. So we do a great job of um, keeping our own agents in line or punishing them when they don't. Um, a lot of this is just general agreement information. So attorney's fees, the prevailing party would receive court costs and reasonable attorney's fees paid back. All of this is per Nevada law. We both have the capacity to enter into an agreement. The entire contract needs to be in writing first off. And then, if part of it were not valid, the rest of it would be. Any of this signed partially, by fax, different copies, electronically, all of that still keeps this as a valid agreement. This, buyer declaration says that you're not in one of these agreements with somebody else already. Um, so FIRPTA, that's the Foreign Investment Real Estate Practice, let's see, Real Property Tax Act with the IRS. So more or less, if the seller is a foreigner that does not pay U.S. taxes, we have to ask escrow to set aside the funds so that they can send some of the proceeds to the IRS. We have done that a number of times and have no problem assisting that should one of these situations come up. Um, Otherwise, this form has been created by our Greater Las Vegas Association of Realtors and their attorney. However, there are no representations made for legal validity of this or any tax info. If you have any questions about any legal questions, tax questions, please contact your attorney. Please contact your CPA. Otherwise, we sign below. You'll see some sections that are lit up if we haven't already entered them to type in your address, city, state, telephone number, email. I'm going to go ahead and just click on my name because I've got everything entered there. I'm going to go ahead and click the little box, although I'm going to stay in review because I'm not done discussing this with you. So that was the brokerage agreement. Now we're done really with the paperwork, but I do like to go through uh, our typical residential purchase agreement just to make sure that you don't have any questions in the future when, it's a time that we might be rushing to get an offer out, maybe there's multiple offers or bids, and we really want to make sure that you've got a shot at getting the property. So on here, you'll see your name, the property address, the date, the purchase price that we're offering. Over here, we will have the earnest money deposit amount. Typical, let's say three, five, $10,000, depending on the price of the property. Typically, we don't have an additional deposit. Maybe in a circumstance where it's a short sale, but that's very rare. Most of the times, we are getting a new loan. We would notify the seller, hey, we're putting 20% down. So on this $400,000 house, we need a $320,000 conventional loan, and we'll check that. We would show, the balance of the purchase price down here. So let's say it's 10,000 here, 320 here. We'd have $70,000 listed here. As we go along, within a couple days, we would send in a new loan application to our lender of choice. And you can be shopping multiple lenders, and you don't necessarily have to use the lender that we submitted the pre-qual with. For some reason, you're getting a better rate, let's say with your own bank or somebody else, you can definitely use them. And let's discuss that should you have any questions about that. But I highly suggest you shop multiple lenders. They will all have different closing costs, different percentage rates, and frankly, you'll probably just get along with different people differently. Then we can go into contingencies. So typically when you have a loan, there is an appraisal contingency. I like to give about 3 weeks. Most appraisers can be done in 10 or 12 days. Sometimes it's a VA loan might take a little bit longer to get back. Loan contingency, again, your lender should know within a week or two if they have any issues with your loan application. And these contingencies give us the right to back out and get your full earnest money deposit back. Now, let's say we weren't getting a loan and it was a cash purchase. Typically, we submit proof of funds along with our offer, so we don't necessarily need to provide them the evidence within a few days, because to make a bona fide offer, they're going to want to see the proof of funds in advance of accepting our offer. If this agreement is contingent upon the sale of another home, which has really died off a lot lately, but does happen sometimes, we do need to check this. And there is another addendum that we attach, if the property's in escrow, things like that. So we can dive into that more at that time. So fixtures, personal property. This is a list of all the different items that are considered personal property, and that should stay with the home unless otherwise dictated in writing. A few things that people mistake for real property and personal property are that all appliances typically stay except for the washer, dryer, and refrigerator. Typically in Clark County, those are considered personal property. So if those are part of the sale, we do want to note that here. Maybe something special like a storage rack in the garage or a shed, or something that may not be a permanent fixture. From there, we have our escrow company. So we will be happy to make suggestions to what escrow and title company you use. You do have the right to pick anybody you want. The seller cannot tell you who you have to use. If they do, it is a violation of RESPA. And however, if you want to be competitive and there's 20 offers out there, it might make more sense to let them choose if you really don't care. If you don't have anybody, we are happy to recommend a few people. We've been working in Las Vegas for over 14 years now. So we know a lot of people, know who to do business with, and are happy to make those recommendations. The earnest money deposit will need to be deposited usually within 1 business day. We do not accept earnest money deposits anymore as agents. We have you wire the money directly to the escrow company. So, when we open an escrow, we will have the escrow company send you wiring instructions directly to make sure that that's going to the right account. We will note the close of escrow date. So a lot of times a typical loan, is 25 to 35 days. Excuse me. And we'll set the closing appropriately for that. Sometimes on VA loans, they're closer to 45 days. We would definitely work with you. If you have a time crunch, you need to move faster or you need more time, and we can discuss at the time we're making an offer what type of close date you're looking for. If it's not important, then we'll do the best we can to make sure your offer looks as good as possible to the seller. IRS disclosure, that's more of a seller issue, and a lot of this will be buyer and seller items. Title insurance, so the seller will have to deliver clear title unless you agree otherwise in writing to not convey with proper title. I've only had that happen one time, um, but 999 times out of 1,000, you're going to get clear title um, at the close of escrow. Any unpaid liens, things like that would all get paid off. Buyer's due diligence, I would always suggest the property is inspected. Typically, we ask for a 10-day due diligence period. At that time, we would set up a home inspection. I am always going to recommend a home inspection, and not only a regular home inspection from a licensed home inspector, but I'm also going to recommend that we use somebody that does infrared scanning. The reason that is important is because probably 20% of the time or more, we found other problems that you can't see with the naked eye. So these infrared cameras will scan the walls, the ceilings, electrical outlets, your panel, your AC units, all these things. And they'll show if the items are too hot, too cold. We found brand new homes with no insulation. We found water literally inside a wall that you couldn't see yet, just started leaking. We found all kinds of things that would just amaze you. A plug on the wall that looks fine, but if you touch it, you would almost burn your hand because it was wired wrong. So great to have a really good home inspector do their job for you. Um, the buyer does have the right to cancel, but everything needs to be in writing. So anything we do, again, in real estate, just it always needs to be in writing. Let's not take anybody's word for anything. It is thought that if we do not cancel in writing, that we're waiving any conditions prior to our time frame expiring. Inspections, um, before the end of the due diligence period, we do need to prepare a buyer's response for repairs and a request to have those fixed. A lot of times sellers will just offer money, which I'm usually in favor of unless it's a habitability issue, because then you can have the vendors that you want and give you warranties on the work make the repairs. Um, the seller does have to provide the property with the utilities on so that we can check everything. They can't just have the power off, gas off, and kind of what's the point of doing the inspection. Here are some items that we note. Typically all this has to do with the buyer's due diligence. So typically the home inspection, we're going to have on there. If there is a pool and spa, we might add that on. A lot of home inspectors will do that anyway. Um, if you're worried about a roof inspection or if it's a larger property, maybe there's a survey or septic, well, wood burning, fireplace or something. So we can have those things all inspected. Certifications we don't run into very much unless we find a problem, which we can add later if we need to. If we find mold or a roof issue or something, we can get a certification required later. Um, it is our job to inspect the property sufficiently and make any requests based on also the seller's real property disclosure form, which we'll go into a little bit lower. Yeah, we'll get into that in just a second. Fees and prorations. So the escrow fees are typically split 50-50 in Clark County. The real property transfer tax is a fee that goes to Clark County. It's $5.10 per thousand. That is a seller fee. Lender's title policy. So because you're getting a loan, there is an additional title policy that your lender will likely require. That is your cost as well as the appraisal. The owner will pay for the owner's title policy, and that's the one conveying the clear title to you as the buyer. Prorations. So all prorations are based on a 30-day month, and they take place, let's say we close on the 15th. So the seller will pay, the property taxes, insurance, HOA, all these things up to the 14th, and then on the 15th moving forward, the day we're closing, you'll pay for those, and you'll see all the prorations broken out on the closing settlement statement. We will get probably a few estimated ones in advance for review, and then obviously we'll have a final once we are done. We will receive a preliminary title report. If you'd like to review that, we can do that within 10 days of opening of escrow. Um, Sometimes when buyers don't have a lot of money down, they ask for closing costs from the seller. In a competitive market, we're not gonna be doing ourselves any favor by asking for that. But sometimes when the market slows down, that is okay, and we can ask for that kind of stuff. Sometimes people say, hey, instead of offering 200,000 for this house, let's offer 210 and then ask for $10,000 back. And sometimes that works. However, we have to also make sure that the property can actually appraise for that amount of money. Otherwise, um, the appraiser won't let the sale go through. Let's say it is worth 200,000. They won't let it go forward, and then the whole deal's falling apart. You've lost your appraisal money, your inspection money, which that could add up to $1,000 between those two items. So these are definitely things we want to talk about in advance, just to make sure that we're protecting you and your money and your interest as best as possible. Home protection plan. Um, if you've had good luck with those in the past, you are welcome to buy them. You can waive it or you can require it. If you'd like a list of some home protection plan providers, we are happy to supply that to you. Transfer title, just like we talked about. Everything will be free of encumbrances, excluding, property taxes, CC&Rs, master planning, anything, that kind of stuff. Common interest communities, we went over this just a minute ago with the CIC disclosure. And then there are a couple of added items, however. For example, if we don't receive the CIC package within 15 calendar days of acceptance, we can cancel without any penalty. So, these are very buyer-friendly agreements, and as long as you fully communicate with me, I can make sure that you're protected as best as possible. But if you go down to the last day, that might be a little bit different story, and we can talk about that a little bit lower. Again, everything needs to be in writing, cancellation. CIC, the HOA related expenses, there's typically a demand letter, which is the accounting of the HOA, the bills due that the seller needs to pay, any future nearby bills that the buyer would need to pay. Seller typically pays that. There's the CIC capital contribution. A lot of times when a new person's coming into an HOA, they ask that they make some type of contribution. It's usually about $100 to $200. And then there is the CIC transfer fee. So again, the demand and the transfer fee are usually seller cost. I always try to push these off, the CIC capital contribution off on the seller as well, but a lot of times they'll come back because it's more typical that a buyer will pay that. Disclosures. So the seller's real property disclosure form, that's a big one here. What that form is the seller saying, hey, here's everything I know wrong with the property, its history, anything that I know. A quick story, the seller of my home that I bought from my family did not disclose things properly. They did not disclose to me that there was a massive roof leak and that they did a patch job and decided not to tell me until 6 months later on Christmas Eve when my roof was leaking in on my stairs. So luckily I know the law and was able to go back and recoup my damages. So it's very important. I don't know why everybody doesn't just disclose properly. They should. They would help everybody involved, but 99 times out of 100, we will have good sellers. I think I just got that one bad one. But the seller's real property disclosure form is where they're going to list, were there any recent floods or do they have electrical problems? Is something not working? Do we have an HOA? Do you have shared walls? Just anything you could think of. And we'll go through that together as well. If the property is newer, we might get a construction defect claim disclosure, if it's marked yes on the seller's real property disclosure form. And then also if the property is built before 1978, there is lead-based paint disclosure. That's federal law, and they would have to provide that to us as well. Federal fair housing, again, we will not work with anybody that is asking us to violate any federal or state fair housing laws. Walk through the property, we do have the right to Um, Walk the property before we close. I like to make sure that repairs were done, that we requested, or that appliances are still there, something funky didn't happen. So that's always good. And actually, I prefer to do it, as close as possible to the closing, just a little bit better. Delivery of possession, typically COE is the close of escrow. So we're going to typically close and get the possession of the home. Or if we have some other specified date, maybe you're leasing the property back and you're moving in early, or the seller is leasing it back and staying late. We can work those types of things out. Risk of loss. Let's say part of the property is destroyed. You do have the right to back out if there's substantial loss. Let's say the house burns down or a plane crashes into it, just something ridiculous. You could back out. Assignment of this agreement. This agreement is not assignable. Cancellation, everything needs to be in writing. Default, again, with the mediation like we talked about earlier, as long as the buyer and seller agree in advance, our GLVAR, our Greater Las Vegas Association of Realtors, does have a great mediation program. If the seller defaults in their performance under this agreement, the buyer does reserve all legal rights to pursue any damages or seek specific performance, meaning forcing the seller to sell. If the buyer defaults, it's typically thought that the seller's sole recourse is the earnest money deposit. So typically that's why you're going to want to, or why you're going to see sellers ask for a greater earnest money deposit. These are escrow instructions to tell the escrow holder what to do, how to deal with unclaimed funds, very rare circumstances. Broker compensation fee, so that $350 we noted above in our buyer brokerage agreement. That's why this is marked buyer will pay buyer's broker additional compensation. Waiver of claims. Everything, again, needs to be in writing, so we're not going to base any representations off of something that was said, without us verifying it all in writing. Definitions. So this is nice. We actually have a little bit of a cheat sheet. If you want to know what a CIC is, or a COE, or a GLVAR, it's all listed here. So great little cheat sheet to reference. Signatures, deliveries, and notices. Again, everything can be in writing, electronic, handwritten, wet signature, fax, it doesn't matter. IRC 1031 exchange. So if, let's say the seller is using a tax deferred exchange to avoid some current tax consequences and they're pushing that off to later, there's usually a few extra forms that both parties need to sign. So we are agreeing to cooperate with that, and really it should be no problem to do. Otherwise, no changes to this agreement unless it's all in writing. This is a legally binding contract, and all parties are advised to seek independent legal and tax advice to review the terms of this agreement. Just like the prior agreement, this one has been written and approved by the Greater Las Vegas Association of Realtors, and we are not tax consultants, we are not attorneys, so we cannot give you advice on either. This is a benefit of being a realtor. We do get forms like this made for us, and we get to use them. If there were other addendums, they would be listed here. If there were other terms, it would be written in here. Under here, this is my information. The buyer has to disclose their buyer's information and their broker information, the buyer broker information, to the other party, and just the same, when we're filling this out, the listing agent's information, I will put all that in here. If I were to have an interest in, your purchase, which I don't, then we would mark here, that does, I do have an interest in the property. Or if you are a licensee, you need to note here that you do have an interest. And I would say if you have a license in any state, let's disclose that. Or if you could potentially be an heir to this property or something, that type of stuff needs to be disclosed. But if you have a question on that, let me know. We do put an expiration on the offer. We don't want to just leave it out there in perpetuity. So, maybe we say 5 p.m., 2 or 3 days from the time we write the offer. And then again, you'll be able to sign electronically. We can send all that over to you, make it really easy. And then we provide this to the seller and they fill out their information. They do or do not have any interest as a real estate licensee. If they have any responsibility under FERPTA. They have to declare that and sign that off here, and then they'll accept, counteroffer, or reject the agreement. From there, I welcome you to ask me any questions. Feel free to email back, call, text, whatever is convenient for you, so that we can make sure you have all of your questions answered as soon as possible. Um, Anything else? Let me know. Thanks so much.